The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Welcome everyone to Richmond and to the Fourth Circuit Court of Appeals this morning. It's good to have you here. We have interesting cases and good lawyers. We're going to enjoy the morning. In the first case, United States versus Ritter. Ms. Van, good to see you again.
Good morning, Your Honor. May it please the court. I'm Lindsay Van, representing DeQuay Ritter in this matter. Ritter's convictions were tainted by highly prejudicial, inadmissible evidence that was presented by the jury that could not have been cured by the judge's curative instruction, and by a juror who was biased in an undisclosed way related directly to the issues in this hate crimes trial. The district court abused its discretion in refusing to grant a new trial, and each error individually warrants reversal for a new, fair trial before an unbiased jury for a determination of guilt based solely on admissible evidence presented in court. I'd like to start with the hearsay that was presented in court. The district court abused its discretion in finding its curative instruction cured the prejudice of an inadmissible hearsay confession. At the trial, a witness named Korea Mallory testified that Mr. Ritter's uncle took Ritter in the car.
Why do we have to accept your characterization as a confession, right, as opposed to a rumor for which there were lots of other mentions of it? I understand the argument you make based on the timing, but
Yes,
that
sir.
seems like an odd thing for us to do, is to make an inference against the government in the posture that we're in.
Well, the question at this point is, what was the prejudice, what was the harm in what the jury heard? And the only logical inference from what the jury heard based on the context of the statement was that it was a confession.
How can that be? I mean, the only logical inference, it seems like if what was meant was Ritter told me he killed Doe, that's what he would have said, not, what was it? I heard Ritter kill Doe? I mean, it just isn't how normal people talk.
Well, based on the context, it could only have come from Ritter. And so she knew that Peoples had gone with Ritter by himself, was in the car by himself, and that's how the jury would have heard it. She testified that Ritter came to the house, talked to Peoples. Her son wanted to go with Ritter and Peoples in the car, but that was refused. So they were in the car together for about 20 minutes. And the phone call was made while they were still on that trip. There was no testimony of Peoples interacting with anyone else or hearing it from anyone else. And so that context would have given the jury the inference that information came from Ritter. The only person that they had heard was with Peoples at the time.
Can I ask you just another question about sort of the way the statement is phrased? Like when we think about curative instructions and confessions, I think the idea is that, you know, a confession can be so vivid that it's just going to stick in a jury's mind no matter what the instruction. But those are cases where, you know, you're looking at a videotaped confession, or where at least, you know, it's testimony that, you know, this guy told me he took a gun and he blew her brains out. It's something really vivid, and that's the concern, that it's going to leave this indelible impression. But, you know, I heard Ritter kill Doe, even if, assuming the jury from context would piece together that that's something like a confession, it's just not clear to me why an instruction wouldn't take care of the problem there. Do you see what I'm saying?
Yes, I understand, but I think the timing of how the jury heard this, I was sitting in the courtroom. I heard it as, oh my goodness, she just testified that my client confessed.
But Judge Leiden was sitting in the courtroom too, right? And so, I mean, that's a little bit of the problem. I understand, obviously know you well, totally
Yes,
trust
sir.
your judgment on it, But the reason we sort of give a great deal of deference to the district court judge is because the district court judge was there and lacks an obligation to zealously represent any particular party, right? And so, like, Judge Leiden was there. Doesn't seem like she took it the same way you did.
Well, she abused her discretion in her denial of the new
Were you
trial.
the trial?
Yes, Your Honor, I was
lawyer?
the trial lawyer.
You were in the courtroom too.
Yes, Your Honor, I was in the courtroom. She abused her discretion in denying the new trial by ignoring the context of the statement, and she attributed this to the rumor mill, which I agree was definitely discussed during the course of the trial. But that was a defense theory that over the course of this 3-year investigation that resulted in Ritter's arrest, that the rumors around this small town over the course of time coalesced around Ritter. I heard Ritter did it. We heard that over and over again.
But weren't there rumors from that same day? I mean, it wasn't like the rumors only started 3 years later, right? They started the very day of the murder.
Well, they didn't start. There was no testimony that they started as quickly as this, and so I think it's important to look at.
But you agree with the print? There was testimony they started the very same day. We just don't have a time stamp on those.
There was some testimony, but there is a bit of a timestamp. So the judge in her ruling cites multiple instances where she says there's evidence that rumors started that day on the joint appendix, page 1467. But Chief Wiggins, who was the chief investigator on this, testified that it was within hours. Delasia Green testified that she saw it on Facebook that night after it had gotten dark. But the testimony from Mallory and the government's theory is that at 4:41 p.m., Ritter is answering a call in the car with the victim. Then he immediately walks to people's house only a half a mile away and is in a rush to leave. And they leave and go in the car, and Mallory makes this call 30 minutes later. And so it's very quick. It's likely that when she drove by the crime scene, it was right after law enforcement had arrived, and there wasn't time for the rumors to spread. Admittedly, we thought the evidence was going to...
You've been in small towns. It doesn't take too long for things to get around Allendale.
It does not take too long for things to get around Allendale. But even Chief Wiggins, our theory was it was getting around so early that by the time he got to Ritter to interview him later that night, that this was what we thought before trial. But Wiggins said by the time we got there, it was just that Ritter had a relationship with Doe. It was not thinking that he had committed the crime. Wiggins talked to people at the crime scene from the community, and they were telling him that it was a relationship. He didn't leave the crime scene later that night thinking that Ritter was the perpetrator. And so with Mallory's...
But, I mean, the challenge I've got, and I'm happy for you to move on, but the challenge is like, I understand that you might make that inference, right? But you might just as well say, law enforcement's often like a step behind on the rumor mill, right? And yeah, things, didn't get posted until after dark on Facebook, but, rumors tend to circulate a bit before they get posted on Facebook. So none of those things seem to require me to conclude that there was no other way that this information was available absent a confession.
Well, I just think that looking at Mallory's testimony, that she is saying that Ritter and Peoples are alone together for almost the entirety of the time before she makes the phone call. She says they're in the car alone together. There's no other way indicated in her testimony that he could have uncovered that evidence.
What was wrong with the curative instruction?
The curative instruction, there's nothing in particular wrong with it other than because
nothing wrong with it.
because there was a confession,
And jurors are presumed to follow the instruction.
Yes, Your Honor, but because of the prejudice of this particular statement, it overcomes that presumption. I also will say, while the language of the curative instruction is fine...
Did you get some input into the curative instructions, or the judge did that on her own?
The judge did that on her own, but then we did have some discussion with the government and the judge about what the curative instruction would be. The problem...
But you don't complain about the content of the curative instruction?
Not the content, but I will say the timing makes a difference here. So the statement, he said he heard DeQuay killed Dime Doe, happens. There's a sidebar. judge gives the government a chance to clear it up. So there's some discussion of her grand jury testimony, then there's cross-examination, then there's redirect, then we take a lunch, and then she comes back and makes the curative instruction. And so they've sat with that for, a couple of hours, or at least an hour and a half at that point after the lunch break. And so it was not this immediate curative instruction that we see in some of the other cases.
But it was emphatic. The judge's instruction, I am instructing you to disregard that statement as evidence. You are to wipe it from your minds as if it was never said. It is not evidence. You cannot treat it as evidence. And you have taken an oath to follow my instructions.
Yes, Your Honor, that was, it was emphatic, but our
And
position.
you want us to recognize the proposition that they didn't follow the instruction.
Yes, because of the prejudice of this particular this confession testimony. And this was not a harmless error given the weakness of the government's evidence, as we pointed out in our briefing. I would like to talk about the biased juror issue as well. So the jury foreperson on this case was a transgender woman who said that that wouldn't impact her decision, that she would be able to be impartial and review the case solely on the evidence at court. But her actions after the trial show that she was in fact biased. She reached out to the Associated Press right after trial.
Is this were we reviewing Judge Leiden's credibility determination here?
No, Your Honor.
Why not? Because Judge Leiden seems to sort of ask these questions and decide she's not lying.
Well, this is looking at the evidence for, looking at the judge's decision for abuse of discretion, and one way in which
But we think about abuse of discretion in a couple of ways, but credibility is one of those places where, you don't want to call it super abuse of discretion, but like, we give a ton of deference to trial judges on credibility determinations, and this sort of seems like you're saying Judge Leiden should have found that this juror was lying.
Well, no, I think as the Porter decision of this court citing Justice O'Connor's concurrence in Smith versus Phillips, it's difficult to uncover bias. One, because jurors may be unaware of it. Two, because they may want to be hiding it. And so this court in Fitzgerald recognized that Sixth Amendment claims of juror bias can be based on additional circumstances outside of voir dire, recognizing that a juror saying that they are not biased is not the end of the question, and you should look at their actions. So Judge Leiden failed to account for the for the juror's actions, and didn't take into account the fact that the juror told the press, if one of us goes down, there will be another of us on the jury. She's referring to transgender women. This is showing that she is willing to use her jury service as a way of furthering her advocacy on behalf of trans women who are facing violence. She also, in the media, highlighted her own personal experiences of transgender violence, which she had not disclosed during voir dire. Later, she testified that that was actually discussing general experiences. It wasn't her own personal experiences. And Judge Leiden didn't take into account the fact that those were not experiences she could have learned during the course of the trial. The trial was only looking at one particular instance of violence against transgender women, not the issue more generally.
Can I ask you a question before your time's up on your sufficiency challenge?
Yes, Your Honor.
And I'm trying to understand what the causation is required here. And the statute says because of actual or perceived gender identity.
Yes, Your Honor.
But then gender identity is defined as actual or perceived gender-related characteristics. So when you put those together, like what it says is that they were killed because of actual or perceived gender-related characteristics. That seems like gibberish, just the way it's written. What do you understand that to mean in the context of what the government was required to prove?
Yes,
I'll let you answer that, maybe open-ended.
The government was required to prove that the crime was committed because Dime Doe was appeared to be a transgender woman.
So why is that? Because in that definition of gender identity, and in the statute, I don't see any reference to being transgender.
Well, it was
I
charged.
mean, I agree, lots of people, I mean, the district judge said it was because of transgender. The arguments were because of transgender. I just don't see that in the statute, and maybe I guess I'm trying to understand, why should I read transgender into that statute when it's not there? I mean, gender-related characteristics involve a lot of different things, and we can imagine lots of things that would fall into that, like the clothes you wear, as well as more physical, attributes. But none of that's like about trans necessarily.
Yes, Your Honor. I think where that came from and how that made it into the court's instructions was how it was indicted. It was indicted that it was because of Doe's transgender identity.
But the indictment had to be consistent with the statute.
Yes, Your Honor. I see my time has
I think
expired.
I'm sure Judge King will give you, if you've got something you want to add on what you think this means. I mean, so you think the statute means because of transgender status?
I think you're correct. I mean, obviously you're correct in reading the statute the way that it is written. I think because of how it was indicted, it became an issue of the transgender identity. But regardless, the point is that there wasn't evidence showing that this was because of Doe's gender identity, whether it was trans or otherwise. There were, they relied on the messages that really show kind of ups and downs in the relationship, but no threats of violence, no specific issues with gender identity. And unless there are further questions, thank you, Your Honors.
Thank you. You've reserved some time. Mr. Goldman?
Good morning. Your Honors, and may it please the Court, David Goldman representing the United States of America. Dockway Ritter is currently serving 2 life sentences and an additional 20 years in prison because he couldn't bear the thought of the world finding out that he was having a sexual relationship with someone who identified as a transgender woman, namely Ernest or Dime Doe. So Ritter shot Doe in the head 3 times, burned his own clothes, tried to get rid of the gun, lied as he concedes repeatedly to the police, and then fled the state. After hearing 5 days of, in the district court's words, overwhelming evidence of guilt, a jury of his peers took less than 4 hours to return guilty verdicts on all 3 counts: a bias-motivated killing, murder with a firearm in relation to a crime of violence, and obstruction of justice. This court should affirm. So my goal is to help you all do that in the most straightforward way possible. And
Not to hijack it, but can you start with this question of what in the world this means when it says, inserting the definition of gender identity, because of actual or perceived gender-related characteristics? Like
Sure.
Start with what it means to have actual or perceived twice, like what that possibly means. Like, I've tried to draw a chart, I can't quite figure it out. And then whether you think there's some connection to transgender status that is a part of that or necessary part of that. Help me understand what it means.
yes, Your Honor, but if I may,
There were
I'll
like 4
actually start
questions in
first.
there, but yes.
Yes,
doesn't
but I'm
help.
actually going to add a first question in there,
Yeah.
which is that whether this was briefed or raised below, it was not. So as the Supreme Court recently reiterated in Clark versus Sweeney, party presentation does matter. So
I
I'm
understand,
happy to answer the
but
question.
we have to understand what the statute means, and
Yes.
it may well be that the incoherence here wasn't brief, but I'm trying to understand what it means, because I have to evaluate the district court's ruling
Yeah.
that the claim was, or the charge was satisfied because the victim was transgender. Right?
Yes.
That's what the district court's ruling was.
Yes.
And if that was a legal error, then I don't know what to do with
and
that.
again, I'm not going to try to fight you on
Yeah.
that. I'm happy to answer
Right.
it, but I will
Did you write
also.
the indictment?
Excuse me?
Did you write the indictment?
So I have to confess, I was not in the courtroom. I am the lone person here who is not
You were
involved
not in
in
the
the trial.
courtroom.
No, and I didn't write the indictment either.
But I didn't ask you if you were the court.
I did not write the indictment.
I asked you if you wrote the indictment.
But,
Yes.
and the indictment doesn't use the word transgender at all, right? It uses the word gender identity.
Sure, but the jury instructions did, and as this court
Well-
as this court's flagged before, if the jury instructions are not challenged, we evaluate for consistency.
No, actually, the jury instructions don't
Okay.
precisely, right?
Oh, that might be my error then. But I'm happy to answer the question.
What it said, I mean, jury instructions are actually quite clear, right? It says because of actual or perceived gender identity, and then it defines gender identity means actual or perceived gender characteristics.
Okay, then that's
It then
my
goes
error.
on to describe what a transgender person is.
Sure.
But gives us no reason why that's relevant.
Yeah, so I'll just move on to the question then.
Yeah.
So the way I would read that is that when you're defining the gender identity, the actual perceived gender characteristics are in the mind of, in this case, the victim. So as Doe perceived.
So this is the second use of actual or perceived?
Yes, within the definition, the embedded definition.
Okay.
And so Doe acts on that, and there was plenty of testimony that Doe dressed as a woman, told people essentially that was Doe's identity. The second part of actual perceived would be from the standpoint of the defendant, because the defendant.
How do I get that?
Well, it's the actual or perceived fill in the blank protected characteristic of the victim. And so the point is that Congress is trying to criminalize, I commit a crime against Jews. Well, it turns out they're not Jews. Well, that's not a defense, because that's not the harm that we're trying to
Because that's
block.
your perception,
Yes. Oh,
right?
sorry.
As the defendant, the
Yes.
defendant's perception.
Yes.
Right. So if I'm a, I don't want to make it me.
Mm-hmm.
I'll make my law clerk. My law clerk's a misogynist,
Yeah.
and so he goes and he kills someone that he believes to be a woman.
Yes.
Because they're a woman.
Mm-hmm.
He's guilty under this particular provision. Doesn't matter whether in actuality the victim is a woman or not, right? As long
That's
as he
correct.
perceived it that way.
Yes.
Right, but that's the first set. That doesn't help me with what the repetition does, right?
Right, so I think
because the point is, it doesn't matter whether if he perceived the victim to be a woman,
Yeah.
and he did it because he's a misogynist, then what the victim thought about him or herself makes no difference.
Well, I think that's getting at the unique nature of what gender identity is, which is that it is in many ways revolving around one's perception of oneself. So it's hard to avoid the actual or perceived language in the definition, because part of often what it's referred to as when we're referring to someone as transgender is I perceive myself as having a gender different from perhaps what my sex is.
But if you're not conveying that, the defendant here is not going to know it, right? So because it has to be in the mind of the defendant. Because of has to be from the mind of the defendant.
Yeah.
Right? So I guess what I'm trying to get at is maybe let me ask a different question and then I'll stop and let my colleagues go. Because I'm totally confused by this. Is there any scenario under which you could charge somebody for actual or perceived gender identity that you couldn't also charge them for actual or perceived gender, which is another provision?
Yes.
These two charges seem to me to be wholly they're absolute matches for one
So
another.
I don't think they're absolute matches.
Give me the example that you think.
Yeah, you are walking, you have a gang of people walking out at night, and they see someone of either sex dressed as the other sex, and they think, we don't like that, that's not proper, I'm gonna go attack this person because I don't like the fact that you're transgender.
Right, but
I think
maybe let me ask. I think what you're saying. So do you think Bostock doesn't apply because of the rule of lenity?
Sure, that's right, that's where I figured we were going with this. I think that essentially Bostock recognized that there are some statutes where you have both traits listed, and I think that's part of the reason why Bostock is really focused on the text of Title VII itself and on that particular circumstance, because it recognized that these two things are not necessarily synonymous, and you do have statutes where you're going to have them separately listed, and they do not always coincide. If I may get to the hearsay issue, which was the bulk of the argument so far this morning.
Going back to that.
Yeah.
It's the government's position that that was a determination or an element that was required to be found by the jury.
The perceived gender identity?
Yes.
Yeah.
That you alleged willfully inflicting bodily injury because of the victim's actual or perceived gender identity,
Yes.
as required by the statute.
Yes.
And you alleged it in the indictment,
Yes.
and the jury was required to find it
Yes.
under the evidence, and that was done.
Yes. Would you like to discuss the sufficiency of that element? 'Cause I'm
His
happy to.
question is, what in the world is Judge Richardson talking about?
If I've misperceived the question, I'm happy to answer it. Have I missed the question?
Pardon? I read you what.
Okay. Yes, I agree that that is.
I've got that language out of your brief here.
Yeah.
And you're saying that the jury found that.
Yes, absolutely. Yes. To get to the hearsay issue, so again, yeah, so the question here, as has already been discussed, is not whether this admission was proper,
The
but
question
whether.
is whether the statute applies here.
Well, actually,
And if the
yes.
statute, and if the statute doesn't apply, all this thing's void, right?
Well, it would not be void because, again, the defendant has never raised an issue that this was not properly charged or not properly prosecuted, and that would be on the defendant to raise. So if I may get to the hearsay issue, there was no abuse of discretion.
You would argue that to be harmless error?
Well, it's not harmless. It's not a complaint of error at all. Again, I mean,
No,
again,
go ahead.
Again, I mean, the Supreme Court recently made very clear to this specific court that we cannot be looking outside the briefing to decide issues to vacate jury convictions and convictions generally.
That's not totally clear, right? So what the court says is you can't make up a new claim, right? So like, you can't make up a new claim. What it doesn't say, they've challenged causation on the sufficiency of the evidence.
Yes.
Right? And so the legal predicate to that question is, what is required to show causation? Right? They've made that argument. To be fair, they hadn't made this particular version of it, but they've raised the claim, they've made the argument. And so I don't think it's the same as the scenario where a court is like making up new claims. The claim has been very specifically raised. There was not sufficient evidence to find causation. The particular citations and reasons that are given might look a little different, but it's not that they haven't raised the claim.
Okay, fair enough. So I guess maybe I would analogize to a claim of plain error, which if we had assumed that he had actually briefed this on appeal, we would ask whether it's plain error. But this wouldn't satisfy the contours of plain error anyway, which usually is defined as requiring that there be on-point precedent.
I'll stop here, but it's not plain error because they raised it in the district court. And what the district court said is that he did so because Doe was a transgender, right? And if that was a legal error, right, it's not plain error because it was raised, and that's what the district court found.
I was just analogizing to plain error because, again, this has been waived on appeal by not being briefed. On the issue of hearsay, we are again talking about abuse of discretion, and I do want to sign on to the skepticism that the only logical inference here was that this was a rumor mill. And I want to clarify some things that have been said before. So, first of all, rumors were circulating immediately after the murder. Delasia Green testified, and with all due respect, I think it was before the sun went down. And she's out in Columbia. She's not even in Allendale. That there were rumors all over Facebook. And also, the phone call was after Ritter was likely dropped off because the store was 20 minutes away. The phone call was about 30 minutes afterward. The district court, as my specific and how vivid they are, this was quite the opposite, and really importantly, what has not been mentioned yet is that the witness who came on right before Mallory gave an actual explicit confession from Ritter. This was Jamie Priester, and she testified multiple times that Ritter told her the day after the murder that he had killed Doe, why he had killed Doe, and there was no question that that was a confession, was already fresh in the jurors' minds. As to the issue about a curative instruction, as Judge King mentioned, it was explicit. As my friend noted, defense approved the instruction. And as for any delay in giving the instruction, well, that's simply due to the fact that defense never actually requested the curative instruction. That was Judge Leiden who came up with it and said, I think I need to give a curative instruction. And then the defense approved it. So any delay really can't be the fault of Judge Leiden here. And then certainly, that has to be presumed to be followed under Chong Lam. And beyond that, it would have been harmless because there was overwhelming evidence of guilt, as the district court found. To touch briefly as well on the issue of Juror 71. So as Judge Richardson pointed out, we maybe don't use the term super abuse of discretion, but we can use the term skilling deference. Under United States versus Skilling, our deference is at its pinnacle here when we are talking about jury credibility findings, because they, of course they are based on things that we just cannot get from a cold record. And as we noted below in our briefing, Juror 71 was asked not once, not twice, but 12 times throughout the course of these proceedings whether the juror believed that the juror could be impartial during these proceedings because of the juror's gender identity or any other reason. Every single time, the juror answered, yes, I can be impartial. And on every single occasion, Judge Leiden found that the juror was credible. And there's no basis for disturbing that. And frankly, if anything, the record evidence of the juror's actions show not someone who is attempting to hijack this trial to prove a point, but quite the opposite. Juror 71 showed a real conscientiousness for the integrity of the trial and the verdict. Before trial, voluntarily approaching the bench to say, I identify as trans, and though I don't think it's going to be a problem, I will let the court decide. After trial, emailing the clerk's office to say, I have found out that a coworker of mine is related to Doe. Again, I don't think it's an issue, but I just want the court to know. If the juror had some sort of aim that the juror wanted to accomplish in this trial, these would all be really silly mistakes to make. I'm also happy to talk more about sufficiency of the evidence if your honors have any questions, but given that that has not yet been discussed this morning, I'm happy to rest on our briefs with that. If there are no further questions, we would ask this court to affirm.
Thank you very much.
Thank you.
Ms. Van?
Thank you. I'd like to start with the harmless error discussion, specifically about Jamie Priester's testimony prior to Ms. Mallory's testimony. Jamie Priester testified that Mr. Ritter had confessed to her son in her son's car while she was in the back seat. She was confused about which day that happened. She initially testified that it was the day after. Her prior statements to the police had said it was on the same day as the murder. This was incentivized testimony. She was trying to help her brother, who was facing federal charges and was in detention at the time that she first alleged that there was a confession. Her testimony about the confession is also contradicted at every turn. She talked about a video circulating, or that could have circulated with Mr. Ritter and Ms. Doe in it, but SLED testified they recovered photos from Doe's phone, including deleted photos, and there was no photo. Jamie Priester's testimony about how the shots happened, saying that Ritter was outside the car and chased the car after it moved, were all contradicted by the other physical evidence that was presented at the trial. And this was all pointed out in the cross-examination of Jamie Priester, undermining the credibility of that confession. Then Mallory comes up and testifies Peoples, Ritter's uncle, heard from him that he did it. So there was no chance to undermine the credibility of that confession from Mr. Peoples because Mr. Peoples never testified at the trial. So what really happened is Mallory comes in with this unchallengeable, inadmissible confession testimony that could not be contradicted, and it props up all of this other testimony whose credibility had been undermined. This is not the type of case where there is a mountain of evidence or overwhelming evidence of guilt. There was no eyewitness or security footage. None of the forensic evidence connected Ritter to the scene. In fact, the DNA under the victim's fingernails and on the cartridge casings excluded Ritter as the contributor to that. And there was also testimony that Ritter was already downtown by the time of the alleged 441 phone call that the government relied so heavily on to say that Ritter was still in the car with Doe at the time of the murder. So really this makes it so the evidence is confused and disputed, and then Mallory comes in with this testimony that couldn't be challenged or contradicted because it was inadmissible hearsay. And for that reason, this is not a harmless
Didn't
error.
you on cross challenge the testimony based on the grand jury testimony?
There was an attempt to do that, but it did not work. And that's another part of the abuse of discretion from the district court. She, in her
I mean,
ruling.
she was there, right? I mean, it's really hard to tell as a lawyer, I mean, as you well know, like whether the cross lands or doesn't land, right? Because it all depends on this group of people that's on the side. It's not your judgment, but what the
Yes,
jury
I
thought,
agree, but I
right?
think the clearest indication that the cross-examination didn't work is on Joint Appendix page 918, where Mr. Kendrick, my co-counsel, says, well, if you didn't say it during the grand jury, that's not true, right? People's never said this. And she doubles down. She said, I don't know why I didn't say it in the grand jury, but I did. That's what he said. And so she really doubles down on it during the cross-examination, which limits the efficacy of the cross-examination. There's no time
Well,
where.
but cross-examination can be effective absent like the witness admitting they're lying, right? Like, I mean, that's the point of cross-examination. Despite Perry Mason, most people don't admit they're lying during cross-examination, but that doesn't mean it's not effective.
Yes, I agree, but I think the fact that she doesn't walk it back at all, she doesn't say that Peoples had interacted with anyone else, she doesn't give any other context besides what the context was when the jury would have heard this testimony in the first place, which was that Ritter and Peoples were alone together, and so that's where he got the information.
Before you run
Yes.
out of time, can I just bring you back to the sufficiency question? And I guess I may have a different view from my colleague about whether arguments are new or not, or have been raised before, but I feel like you're standing up here, and so now, do you want to make an argument that if Mr. Ritter killed Doe because of her actual or perceived transgender status, that did not count as killing her because of her actual or perceived gender identity?
We have briefed this. I don't want to concede
You have
that.
briefed it?
No, I'm sorry. We have briefed this as a sufficiency of the factual evidence
Right.
claim. I certainly don't want to disagree with Judge Richardson or
I'm
concede
sorry,
that.
That would be awkward. I'm not asking you to. I just want to explain
You've done it
why I
before,
was
you can do it
asking the
again.
question.
No, thank you. But I would say, I mean, really what the evidence focused on at trial was Doe and Ritter had some sort of relationship. But really the question is, if Ritter committed this murder, what was happening in his mind at that time? There's no evidence of them even being together or what communications they were having in the car at that time. It was the testimony about perhaps there was a video was undermined by the fact that they never found a video. So I think it's really unclear of what was the motivation of this, and that's simply not sufficient to prove this element of the offense. I'm sorry I went over my time, Your Honor.
As long as you get questions, you answer.
Thank you, Your Honor.
Okay?
Thank you.
Look, we appreciate your arguments. We'll take the case under advisement, and we'll come down and greet counsel and then proceed to the next case. And then our second case today, United States versus Moore. Mr. Byrne, good to see you again.
Good to see you again, Judge. Come on. There we go. May it please the court, my name is Jonathan Byrne. I'm here this morning on behalf of John Moore, the defendant below. Mr. Moore went to trial representing himself in front of a judge who had previously tried and convicted him while he worked for the United States Attorney's Office, who denied a motion to suppress that Moore had filed that was factually detailed without a hearing, and while requiring Mr. Moore to be shackled during the presentation of his case. The district court erred in making all those decisions, and for any or all of those reasons, this court should vacate Mr. Moore's convictions. As to the recusal, I'll start there unless there are questions going elsewhere. This is an admittedly unusual situation in that the question of recusal came to this court on a mandamus motion, actually two mandamus motions, the first one of which resulted in a published opinion from this court. That's one of the reasons it was denied was that there was relief that Mr. Moore could have after conviction if there was a conviction. And so that's why we're here today. And the standard when we're talking about whether a judge should recuse themselves from trial, actual partiality, actual bias is not required. The statute says that a judge shall disqualify themselves if impartiality might reasonably be questioned. And the standard is whether a reasonable or objective person would harbor doubts about impartiality. In this case, you have the background fact that Judge Conrad prosecuted and convicted Mr. Moore. And we've laid out in our brief various things that transpired during the trial that I think a reasonable objective person would look at and cause doubts about the impartiality of the trial. And I think the best example of that, aside from the question of shackling, which is raised separately, was the handling of the evidence related to Mr. Mercado. He was the loss prevention specialist with Lowe's. He testified about some of the video that was recovered and reviewed by police as part of the investigation. Mr. Moore was cross-examining him. He was starting to get into areas that were beyond the scope of direct, and Mr. Moore had the forethought to sort of hold up and say, I haven't called you yet, you're a government witness. This was after Judge Conrad, at the beginning of the case, had said that Mr. Moore's case will occur after the government rests, and partly based on that, Mr. Moore decided to reserve his right to do his opening statement until after the government's case was done. So Judge Conrad at that point with Mr. Mercado said, go ahead, ask any questions of this witness, go ahead and ask them now. But there was not a specific directive that this is the only opportunity you're going to have to ask these questions. So when Mr. Mercado's testimony was over and there was a break in the trial, the prosecution brought up this issue of whether he could be released. And Mr. Moore was like, well, he's subpoenaed, I want him to testify, I have questions for him. And this is when Judge Conrad then said, no, if a witness is going to testify, they're going to testify one time, so you get your cross and anything you have with respect to your case in chief. And Mr. Moore said, well, I'm not finished questioning Mr. Mercado. And Judge Conrad said, oh, you're finished with him. And so that prevented Mr. Moore from recalling Mr. Mercado. But then later in the case, Judge Conrad then said he would hear from Mr. Moore after the government rests putting on his case. So there was this back and forth about Mr. Moore's defense and how it could be presented. And I think
So why, but just connect the dots for me. So why does the, entirely expected confusion with a pro se litigant in federal court suggest bias? I guess that I understand that discussion. What I don't understand is how I then make the jump from that to bias.
Because, I'd take issue with the framing that this was confusion based on a pro se litigant. Mr. Moore recognized that he, as acting as his own attorney, was limited to cross-examining government witnesses based on what they testified to on direct, which is a common understanding of trial lawyers. It was Judge Conrad who injected this idea of, no, you're going to do it all at once, which I think is something a judge could allow a defendant to do. I don't think the judge can require a defendant to do.
But how does that show bias? That's Judge Richardson's question.
Because there's no basis for that. And that
You think if you have a loss prevention officer on the stand and the defense lawyer says, I want to recall this person later, that a trial judge could not, in the exercise of its discretion to manage the trial proceedings, that a trial judge is prohibited from saying, whatever questions you have for this witness must be asked now. I'm not going to force this person to come back in a week. You think that's beyond the trial judge's discretion in managing and running a trial?
I think that would be questionable. That's not what happened in this case.
No, but the premise of what you're saying is there was no basis on which Judge Conrad could do this, right? And so does it turn on that? So if I thought that, a trial judge has got a lot of leeway in how they run a trial and the efficiency of the trial and the manner in which it's operated, if I believed that to be true, hypothetically, then you'd agree this doesn't show bias. That's the predicate that's required to show bias.
I don't think that it necessarily turns on that. But I think it's important to look at what Judge Conrad actually said here, which was not, when Mr. Moore said, oh, you're a government witness, I need to save that. Judge Conrad did not say, Mr. Moore, in order to make things move more efficiently, I want you to ask any questions you have of this witness. Now, he said you could, but not that you're required to. And Mr. Moore, who had already been told your case is going to come after the government's case, who had made his decision to forego an opening statement until the government's case was over, was saving his case. And Judge Conrad did not require him to do otherwise until after Mr. Mercado was off the stand.
And the theory, what you're asking us to say is the reason Judge Conrad did that was because he had bad feelings about this guy from 20 years before.
No, Your Honor. My position is that a reasonable and objective person observing that might have doubts about impartiality. And that is I think, the best incidents that we have here. But we also have, like, the incident involving the admission of Mr. Moore's prior conviction. One of the offenses he's charged with being a felon in possession of a firearm. He did not stipulate to his prior record. So the government introduces a judgment that reflects his prior conviction, that also reflects a consecutive sentence that was imposed at the same time for revocation of term supervised release. So that introduction happens. Mr. Moore objects. Judge Conrad does not let him explain the basis for his objection, just overrules it. Mr. Moore eventually had to go through a third objection before he finally got a chance to explain the basis for his objection. Once he did, Judge Conrad was like, oh, you're right. This is not a prejudicial error, but it is a mistake, and the government needs to, I think the word he used was sanitize that exhibit before the exhibits went back to the jury. And so, again, I think an objective...
It was fixed.
It was fixed, but it could have been fixed immediately when the jury had first...
Timing of it is what caused you the problem. Were you the standby counsel?
I was not, Your Honor. I wasn't in the courtroom. I wasn't even in the district.
He was representing himself,
Correct.
and he had a...
He did have standby counsel.
I assume it was sitting beside him or back on the front row.
I don't actually know the mechanics of that, Your Honor. But he did have standby counsel.
And that, whoever that was supposed to be helping him out with the legal issues.
They were. I don't think there's anything in the record specifically that shows them sort of jumping in, aside from presenting exhibits to the witnesses and things like that, which is relevant to the shackling issue.
Yeah, your client was a layman. I mean, there's no
Yes,
question
Your Honor.
about that.
Absolutely.
But he wanted to represent himself, and Judge Conrad let him do that.
He did,
But
yes. Your Honor.
But he gave him a standby lawyer.
He did. He did give him a standby counsel, yes. Move on to touching on the suppression issue. So Mr. Moore filed a motion to suppress evidence that was recovered from his home. And his motion was factually detailed as to what police officers did after they had arrived at the home and executed the arrest warrant. He made detailed factual claims that suggested that they engaged in an actual search of the home, not a protective sweep, as would be allowed as sort of incident to executing the arrest warrant. The government's response was, well, this is a protective sweep, but even if it's not, here's this other basis for denying it. The district court did not hold a hearing to resolve any of those factual issues, and instead denied the motion on the basis that this evidence would have been inevitably discovered. But in this sort of a situation, inevitable discovery is the wrong analysis. Independent source is the proper analysis when you're dealing with a potential illegal search and then a separate warrant that was executed
Can I just
later.
ask you just a quick question, sort of clarifying that?
Certainly.
Are we talking only about the evidence that was recovered in the with warrant search? Do you know, is that what your client wants suppressed, the evidence that was found when they came back with the search warrant, or does he want suppressed the evidence that was found in the original either protective sweep or unconstitutional search?
Certainly the evidence that was found as a result of the second
The
search.
second search. I
But-
agree
but
with you
also
that
I-
as to the
I
second.
think he would argue.
Was that even introduced at trial, the evidence from the first?
Well, yes, among the things that they seized regard to the search warrant was the firearm.
No, the search warrant, right,
Oh.
but the first, call it the arrest search. Was that evidence introduced at trial? I really am just, because I think as to that evidence, you would be talking about inevitable discovery, but I'm not clear on whether anyone.
I don't think any of that evidence ultimately was
Was
introduced,
introduced at
yes.
trial?
They
Okay.
seized
The
some,
the protective sweep didn't uncover any evidence.
Well,
Is that what you're saying?
it didn't
The
under,
so-called protective sweep, you don't agree that
When-
we're
when-
entitled to a protective sweep?
when they executed the arrest warrant, they seized.
They did a protective sweep. There was a reference to that. You just mentioned it.
Well, that's disputed.
Pardon?
That's disputed.
Well, no, but it was referred to by the court as a protective sweep, or by the officers.
By the officers,
Was
yes.
there something seized in the protective sweep that they wanted suppressed?
I don't think anything that was seized during that
Well,
was,
their motion to suppress doesn't have anything to do with the protective sweep.
well, except that if it was not a protective sweep and it was an illegal search,
Well, they're entitled to do a protective sweep. They gotta protect themselves. They're entitled to do those things.
correct, Your Honor, but Mr. Moore's
In
allegation.
lots of situations.
Yes, but
They
Mr.
gotta
Moore.
protect themselves and everybody there, and the public.
Yes, Your Honor. But Mr. Moore's allegations is that they were doing things like opening a safe and looking under mattresses and doing
But there
all
was
sorts
nothing
of.
seized during this particular so-called protective sweep that was trying to be, that you were trying to suppress.
Correct.
You being Mr. Moore.
So, I'm not trying to make arguments for you, although I have a tendency to do that. What about the, money and things that were found in his coat? Like, wasn't his allegation, and I'm just trying to recall, but his allegation was they found some money and things and a phone?
Yes.
And they then put them in a coat, and then put the coat on him, that then allowed them to seize them when they got to jail? So wouldn't those have been things that are at least arguably seized during the
They were
alleged
seized,
protective
but
sweep?
to Judge Harris's question, I don't think they were eventually
They didn't admit
admitted.
the
I didn't
phone
mean to
or
cut
the
you
money?
off.
I don't think so.
All right, I did not mean to, I was just trying to
That's all
figure
right.
out whether we're talking about independent source and never, but assuming we are talking about the evidence that they, was recovered when they came back the second time with the warrant, I understand your client's allegation to be they were not in the process of getting a warrant, a search warrant, until the officers learned what had been found during the contested protective sweep, and therefore the warrant is fruit of the initial illegal search, right? That's the
That's
basic
correct, Your Honor,
allegation here.
yes.
They looked under the mattress, they found the gun, and that's why they decided to get a search warrant and come back to get that gun, basically.
Correct.
Okay.
And
All right, and then your allegation is the district court messed up because it made half of the findings you need for independent source. It found that they didn't rely on what they found the first time when they got the warrant. So the magistrate didn't have that information, but the district court neglected to find that what happened in the first search didn't affect the officer's decision to seek a warrant. That's the basic argument?
That is the basic argument.
Okay.
I actually don't think the judge made either finding.
Okay.
But the first finding, I think, is clear from the record because we
Okay.
have the warrant
Okay,
application.
I just have one, I totally understand your argument. Just as a practical matter, it seems like mostly with independent source cases, what we're worried about is a situation where it's really not obvious that the police would have gotten a search warrant. But is there any chance in the world that on these facts where they've just arrested, and they have probable cause to arrest this guy for 2 armed robberies that were just committed, they pick him up, they take him to the station, no one has found the gun yet, that they're not gonna get a search warrant to search the apartment where he was arrested to find the gun?
Well, we don't know that, Your Honor,
Well, we
because
don't
there
know it,
was
but is
never a
there a
hearing.
world in which, like, they don't come back with a search warrant?
To be completely honest, I wouldn't have thought there was a world that they would have gone to arrest him and didn't have a search warrant in hand.
That's my first question for your comment.
But they
That's fine.
didn't.
Okay.
And
Okay.
we know from the timeline,
You've done this enough to know that's actually like quite common.
it is, but it didn't, we don't know that it happened here.
Right, but you're just like, you were shocked to learn it. I mean,
I
in fact,
was.
that's like more common than not.
Yeah, I'd have to agree to that.
I disagree. Okay.
Thank you, Your Honor.
Okay.
Thank you, Mr. Byrd. You saved some time. Mr. Enright?
Mr. Enright, I want to know, why, is that common? If the police are going to arrest him anyway, why didn't they check the box for search as well as arrest on the warrant application?
That is pretty common, and I think it has to do with the logistics of how the police work. In this case, there are 2 teams. One team is tasked with arresting people and finding them, and there's another team that's tasked with investigating robberies.
Okay.
And that might seem like, I don't know, bureaucratic largesse or something like that, but I think the main concern is that one team is heavily focused on protecting the safety of a circumstance that can get pretty volatile, which is an arrest and a takedown. And another team is focused on investigating crime, and that separation is, I think, the reason for it.
Okay. I mean, it does lead to exactly this problem, right?
It does, Your Honor, and I want to get to that, but I do want to correct something. Candidly, the jacket and the phone, and not the cash itself, but some testimony about the cash that were recovered during the time by that arrest team, those were introduced at trial, Your Honor.
They were, okay.
Now, I don't believe that my friend raised it, and I think my friend's comments kind of corroborate that. Also because, to a point I think your question pointed to, inevitable discovery would be the only way to evaluate that evidence if you did what the court did, which is assume that there was some misconduct that led to it. We don't need to address that because we're dealing with inevitable discovery. Since it wasn't discovered twice, nobody says it was discovered once, the officers testified to that tune, there wouldn't be a way to say that there's an independent source. Independent source is generally what you apply when evidence is discovered twice from 2 different sources. If they're independent, it's the independent source.
All right, so then why isn't there a problem here? Because the district court, as to the gun, the only way that could come in, assuming that there was an initial illegality, and I understand you don't think there was, but assuming there was, as the district court did.
Sure.
How does the gun come in without the district court finding both that what happened during the initial illegality didn't make its way to the magistrate, which seems clear from the record, but also that it didn't affect the officer's decision to seek the search warrant?
So I have 2 parts to that answer. The first is the court explicitly did find that on page 615 of the joint appendix. The evidence from the apartment will not be suppressed because it would have been inevitably discovered during the lawful execution of the search warrant. But I think the bigger question
Wait,
is...
I'm sorry, how does that show that what was discovered in the first hypothetically or presumptively illegal search didn't affect the officer's decision to get a search warrant?
Because if it had, then the court would have said it wouldn't have, the officers would not have discovered it during the lawful execution of the search warrant.
Because there would have been no search warrant.
Because they wouldn't have gotten the search warrant, exactly. And so when the court does that, when the court says it would inevitably have been found, that necessarily includes a finding that the court would have that the officers would have obtained the search warrant, because had they not obtained the search warrant, they wouldn't have discovered the evidence pursuant to its lawful execution.
If you like shoved as much into those words as you could, as you've done, what would the evidence be that the judge relied upon to make that, what I'll call the motive determination, right? The sort of, the officers would have gotten the search warrant regardless. So if you read it into those language, would have been discovered, like what evidence would the district court have been relying on?
So there is some evidence, because in our response, we attached the search warrant. The search warrant application said there's an ongoing investigation that began at the time we reviewed the videos. So there's evidence, actually before the court, that there was an ongoing investigation beforehand. There's also some...
But that isn't much, right? So everybody knows there was an ongoing investigation. The question is, would they have searched this house?
That's a fair point. Well, they had the location too, because also in that application was, we just arrested them here, and there's probable cause to believe there's evidence in that house. There's also evidence during the trial record, which this court can consider under its precedent, even if it's connection with the motion to suppress. But I think the bigger point is,
Say back that up again. You think we can look to the why can we look to the trial evidence to determine whether they would have gotten the search warrant absent the protective suite?
it's evidence this court can consider when affirming a judgment on a motion to suppress.
And is that because we can consider it in determining whether there's an error?
Yes.
Or we can consider it to determining whether the error was harmless? I understand the latter proposition, right? We might look at the trial testimony and use a little bit of common sense and say, there's no possible world they weren't going to get a search warrant. I understand that argument. But that's not the error argument, right? I don't understand how we could look at the trial testimony to determine whether the district court erred in either not finding or finding something without evidentiary support, that the first search didn't affect the decision to seek the second search.
In candor, Your Honor, I'm fuzzy on the rationale, but I'm actually pretty sure it's the first part. I'm pretty sure this court can consider trial evidence when evaluating the propriety of a motion to suppress. But I think that's...
Do you have anything off the top of your head you want me to look at?
A decision called United States versus Hahn, which unfortunately the citation I don't remember.
That's fine.
But I will... This is what
he'll find it.
This is what 28J letters are
No,
I hope permitted for. I will fix that. Rectify
Trevor
that
will find it. Don't worry.
But a bigger point is this court's precedent, and this I can give you some citations. We cited it in our brief even. Allows the district court to resolve this issue on undisputed facts, and that specifically includes this part of the inevitable discovery and the independent source doctrine, which is the motive part. If we say the inevitable discovery doctrine applies, or the independent source doctrine applies, and the defendant doesn't contest it, who has an opportunity to do so, then the court doesn't need to address it. The court doesn't need to have a hearing to do that. That's what this court said in Hill. And the other decision, the more recent decision, is Bowman, where the United States representation went uncontested, also pro se defendant. And the court said, you don't need to have a hearing. It's within the court's discretion not to. Hill is one we cited, and it distinguished a couple of other decisions where the court only addressed the could part. Did the court obtain or did the officers obtain a warrant without including the purportedly or allegedly tainted information in the warrant, and didn't address the would they have done so part? And the district court, and this court affirmed without addressing itself or requiring the district court to address the question of whether the officers were motivated by that, because it was uncontested.
So you're referring, because he files his motion to suppress and then you guys raise inevitable discovery, and then in his reply, he doesn't come back to
Yes,
that.
he elected not to file a reply, but he filed about 6 other documents.
I thought at that point he changed his mind and went to, is that why you went to the Franks issue? And
He did, and that's the thing. I think his strategy was he wanted to challenge the could part. He wanted to challenge the warrant, and he raised many, many very granular grounds about the warrant. There's a Franks hearing, there's a lack of particularity. He said that the warrants were forged and fabricated. I think that's what he wanted to. As my friend said, his allegations about what he alleged were very detailed. And to your point, Your Honor, this is not a situation where it would be at all easy to prove that they weren't motivated to do this. And his own motion to suppress identifies these two separate teams. One team went and arrested him. Another team went, and it was the robbery team investigating the robbery, and searched him later. And there's no allegation that they ever communicated, hey, look, I found this evidence under the mattress. Go search and look under there. And in fact, there's no allegation that that first team saw anything under the mattress. Only
Is there
that
any
they
reason
searched
to
under
think
the mattress.
that a, you know,
Well,
sorry.
Doesn't he say they lifted the mattress? I heard them lift the mattress.
He did say they
And doesn't he
lifted the
say that's
mattress,
where
but
the
he didn't
gun
allege
was?
that they discovered anything.
But he
which
says
is-
the gun was there, and they lifted the mattress.
He
so
says the gun.
You
He
don't
says.
think we can infer that?
Well, I think the challenge is that he didn't assert that that was ever. There was another. He alleged there were two teams, so that was undisputed.
Yeah.
He never asserted that they communicated that information to the other team and
Does
caused
say,
them to go
right,
get the
I
warrant.
thought he says, like, really specifically, I mean, I thought for a pro se motion, it was pretty good. He says they weren't in the process of oh, God, I can't see, because it's all, that they weren't in the they weren't actively trying to get a search warrant. They only did so after, now I can't read this, but after the illegally seized evidence. After they were shown the illegally seized evidence. Like, that's.
I'm sorry, Your Honor, I may have missed something, but I totally didn't.
It's on
Would you be
page
willing to?
79, J79?
79.
While I was in the investigation room, oh my God, my eyes are so bad, and this is gray, and I have highlighting on it. The detectives came in, and I wouldn't consent. They tried to get my consent.
Yes, I see what you're saying, Your Honor.
Right, they weren't actively trying to get a search warrant. They only did so after they were shown the illegally seized evidence from my apartment.
I think, I don't mean to be
Yeah.
quibbling, but I think what he's saying is they only did so after they was given the illegally seized
okay.
evidence. The reason that's different is because the motion refers to the three items we were talking about before, which is the
Right.
coat
Right,
and
right.
the cell phone and the cash.
Right.
I don't think this could reasonably be read as alleging that they saw the gun and
Oh.
the Nike jacket and then
That's
told
fine,
them
but
about
either
that.
way, he's like earlier, he says they looked under the mattress where I keep my gun. But, I mean, he's very clearly alleging, right, that this is a motive case, because they weren't gonna get a warrant until it was clear it was gonna be worth their time. They were shown the evidence that was seized the first time, and that's when they decided to get the warrant.
So, I mean, you're the judge, Your Honor. I don't see it that way, but I understand the point. I will emphasize, in the light of that note, that if you disagree with me on this, the remedy is in Campbell, which is I think you don't vacate you don't vacate the verdict. You just send it back for a hearing where the outcome determines whether the verdict gets vacated, because that's something I do want to mention. But if it's okay, I'll move on to the recusal issue, which we've been here before on to an extent. The district court acted within its discretion. It ultimately did. This court identified the things that needed to materialize for a disputed issue of fact to come before the court. When those occurred, the court promptly recused, got rid of the case in its entirety. And the sort of trial issues that came up, I do think the answer to Judge Richardson's question is no. A reasonable observer, whether those decisions were right or wrong, and I think every single one of them was well within the court's discretion. Right or wrong, I don't think an impartial observer would say not letting him recall that witness was because of something he learned in 1989. Putting him in shackles, requiring him to wear shackles when he's committed 7 undisputedly crimes of violence and is charged with crimes of violence and serious violent felonies was because of something he learned in 1989, or requiring us to sanitize an exhibit that I think was fully admissible was because of something he learned in 1989. I think, again, all those decisions were fine. And I think we have cases that support all of them, but even if not, that's something he could appeal, but not a basis for recusal. And of course, he didn't raise those issues as a basis for recusal. So it doesn't comport with the timeliness requirement for recusal requests, and it would be subject to the plain error standard to the extent he asserts those. On the question of leg shackles, I mean, I think this court's precedent in Midget and Williams is pretty much on all fours. If anything, the court went above and beyond what it needed to do to protect its due process rights, either needed to keep the shackles invisible or make specific findings of a
They
security
concealed
need.
that from the jury?
What's that, Your Honor?
They concealed it from the jury?
Yes, Your Honor. The court made clear that it took steps to do that the courtroom was designed in a way where the shackles wouldn't be visible, made both parties stay behind both parties give direct examinations and closing statements and opening statements from behind the podium, from behind their tables. And
He had to sit down all the time?
he
had to remain seated.
could stand up.
He could stand up?
Yeah, I don't think he could move around, but I think he
Couldn't
could,
move
but
around.
but he could stand up, because the court directed him to stand up when he's giving arguments and the like, and he had standby counsel to serve as his feet, as I think Judge Whitney said, and so did we.
Was
not
this in the
standby counsel.
the Jefferson courtroom?
It was in the Jefferson courtroom, Your Honor, and Judge Conrad was very proud about the fact that it was designed in a way that prevented shackles from being seen. So I think the court went, if anything, above and beyond what this precedent requires, well within the court's discretion, and it would be harmless in any event. And then on the Apprendi error and alleged Apprendi error, as we mentioned in our 28J letter, regardless of the standard of review and candidly regardless of the merits, I think the outcome is controlled by Brown, because all of the convictions were more than 5 years apart. All of and at least 4 commissions were at least, I'm sorry, using the word all is not correct. At least 3 convictions were more than 5 years apart, and at least 4 commissions were at least 5 years apart. That evidence is overwhelming and uncontroverted, so it's harmless. I will address briefly the 3 strikes language, because there's a pretty material difference between the language of the 3 strikes law and the Armed Career Criminal Act, which is the 3 strikes law focuses on convictions. And the fact of a prior conviction is still an exception under Almendarez-Torres, and Almendarez-Torres' explicit holding, as quoted by Erlinger, is that the timing of the conviction, when compared to another event, is still within the exception. And that's exactly what the 3 strikes law requires the court to determine. So until the Supreme Court overrules Almendarez-Torres, which I think some people have been waiting for about 30 years at this point, I think the court properly applied the 3 strikes law, and there's no reason to even get to harmless error, or plain error for that matter. And I don't think the standard of review is dispositive in this case, but I think Brown also makes clear that's something you have to raise at the time of the conviction, not solely at the time of sentencing. So if this court has no further questions, for the rest of it, I'm happy to rest on my briefs.
Thank you, Mr. Enright.
Thank you, Your Honor.
Mr. Byrd?
I will start very quickly where Mr. Enright left off. When Brown came out, and then when the government filed their 28J letter last week, I did my best to try and figure out a way around it for Mr. Moore, but I just can't do it. So I agree that Brown pretty much resolves any of the sentencing issues here. I wanted to mention the standard of review, particularly on recusal, since Mr. Enright mentioned it. Government argues it should be plain error, but I mean, here we have a situation where there was a pretrial motion to recuse, there was a post-trial, or a second mandamus motion that was filed on the eve of trial. There really is nothing more Mr. Moore could have done to preserve that issue. Any motion that was filed afterwards obviously wouldn't have impacted the trial. So I don't think plain error is the correct standard there. On the suppression issue, I don't agree with my colleague that inevitable discovery applies even to the things that were seized during the initial search, because the inevitable discovery is it would have inevitably been discovered because the warrant, when the search warrant was executed. But of course the whole question is whether the search warrant is valid. So I think it's all bound up in the independent source analysis, for which I think burden of proof lies on the government to prove it applies, not on Mr. Moore to prove it doesn't apply.
Do you have a response to the concern that your colleague raised that when the government opposes this suppression motion based on inevitable discovery, Mr. Moore doesn't contest that? He kind of switches theories and goes after the warrant itself, saying it rests on false allegations and it's not particular enough.
Mr. Moore did not directly address questions of inevitable discovery or independent source. I don't think that leads to any sort of a waiver or forfeiture, because he made the initial request to the court to suppress on this basis, and the district court decided that issue. I wanted to talk very briefly about the shackling, because I didn't get a chance to when I was up here the first time. This actually is one of those indications where what happened in 1989 was relevant, because part of Judge Conrad's ruling on shackling was the nature of Mr. Moore's prior convictions. And I'm not going to stand here and say that his prior convictions don't count as crimes of violence, given our categorical approach and the way that works. But there's no allegation in his history or in his conduct in this case that he's ever been disruptive in court, that he's ever been threatening in court. His prior convictions, and this conviction as well, basically involves the threat of violence, not actual violence, potentially the use of a weapon. And the idea that he might get his hands on a weapon in a courtroom filled with court security officers and marshals borders on ludicrous. And while the jury may not have been able to see the shackles physically, the fact that he could not participate fully in his defense, the presentation of his case the way the United States attorneys could, clearly signals to the jury that something is up. When the magistrate judge heard Mr. Moore's request to proceed pro se and did the Feretta colloquy, the magistrate judge said in explaining, this is what you're going to have to do, is that you're going to be expected to be treated like any other lawyer, and he wasn't. And so, unless there are further questions, I'll rest on the briefs and ask that you vacate Mr. Moore's convictions. Thank you.
Thank you, Mr. Byrne. We'll come down and greet counsel and then take a short break. Is that okay?
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated. And our next case of the day is Harold versus Hagan. Mr. Allen. Good to have you with us, Mr. Allen.
Thank you, Your Honor. May it please the court, Robert Allen for the plaintiff appellant Richard Harrell. The issue presented for appeal is whether Officer Hagan is entitled to qualified immunity for the claims under 42 U.S.C. 1983, counts 1 and 2 of the complaint. This court reviews qualified immunity determinations de novo, and as the party asserting qualified immunity after the appellant in this case has established that a constitutional violation occurred, the burden then shifts to the officer in this case to show that the right at issue was not clearly established. And in this case, that's one of the errors that the district court made below. In its opinion, the district court said, quote, Mr. Harrell fails, however, to establish that the right violated was clearly established at the time of the violation. As a result, Officer Hagan is entitled to qualified immunity. But in fact, the law is clear that Officer Hagan indeed had the burden of proof with regard to qualified immunity and with regard to his argument that the right at issue in this case was not clearly established. So the district court got the burdens backwards in this case, and I think the case should be remanded on it and reversed on that basis alone. The court erred below in focusing only on police canine cases, of which there are not very many in Virginia, and further erred by focusing on cases involving the release of a canine. Furthermore, the district court focused even more narrowly on the issue of whether a warning was given before the police dog was released. It is clearly established that a police officer must give a verbal warning before releasing a police dog. And the warning may sound like, come out with your hands up, or I'm going to release the dog, and the dog will bite you. In this case, as alleged in the complaint, Mr. Harold states that he was not aware that any warnings like that were given. And based on the body...
Why does that matter, right? Why does his allegation that he was unaware matter, given that we have a body video that shows us that warnings were given? And maybe he didn't perceive them, but we look at these things from the perception of the officer, right? And, he's in the same room a minute before the dog bites, and he says, police canine, right? I mean, like that fact we can't do anything with, right?
Right. Well, there is on the video, it's clear that once Mr. Harold is located in this room of boxes, he's on the floor in a fetal position, there's not an additional warning given at that point.
I understand that, and you may have an argument that you have to give a warning not just a minute before, but 10 seconds before or 2 seconds before. I understand that argument. I'm just trying to, you made the point that your client alleged that he was not aware of the warning, but we look at it from the perception of the officer, right? And he says, over the course of the search 5 or 6 times, but a minute or so before the bite, he does announce, right? And so we can't say that there was no warning given. You may have a different argument that there needed to be another warning given, that 6 weren't enough, we needed a 7th. I totally understand that argument, but you can't say there was no warning, right?
I can't say there was no warning given. I can say that the complaint, which is viewed in the light most favorable to the plaintiff at this point, alleges that Mr. Harold did not hear the warning.
No, where does the complaint say there were warnings given that he didn't hear? I thought the only thing the complaint said about a warning was there wasn't a warning given immediately before the attack. Does the complaint discuss whether there were warnings given at some other time?
I don't think the complaint alleges that there was a warning given.
All the complaint says about a warning is that after he found me and before he set the dog on me, he didn't give me a warning.
Right, and that is
Right,
correct.
so what I am wondering is how come we're looking at the other 6 warnings at all? Because they don't contradict the complaint.
Well, I understand where you're coming from. The complaint makes a passing reference, I would say, to the body-worn camera video. So at that point, the defendant in this case was able to introduce his body-worn camera footage, or parts of it, or whatever.
Right,
Part of the video
okay.
was, I'm sorry? Part of the video was made a part of the record. And so then at that point, there are some warnings that are audible on that recording, and so that became the issue.
I know there are, but the only thing, and I guess I assume you are familiar with the complaint, and probably more so than I am. The only allusion to warnings I can find in the complaint is at JA 10, where it says Officer Hagan didn't announce his presence or give any warning at that time that he was going to release the K-9. Are there other references to warnings in the complaint that I'm missing?
Not that I'm aware of, Your Honor.
Okay, then my question would be, why are we looking at the video and the 6 warnings on the video, because they don't appear to me to contradict anything that is in this complaint?
Well, I share that concern, Your Honor.
Okay.
I think that,
We're here on a 12B6 ruling, aren't we?
yes, Your Honor. And so on a 12B6, the allegations in the complaint are presumed to be correct. It's read in the light most favorable to the plaintiff in this case. So I don't know why, I don't think all those warnings should have been necessarily considered. But warnings became a focus of this case, I think.
Have you made that argument? I mean, I understand maybe it's part and parcel, but like, it seems like the way you briefed it is to consider those warnings, and the argument you've made is the sort of narrow one, which is they needed to give an additional warning, right? Not that we should assume, I mean, your briefing doesn't say there were no warnings given. And if we interpret it the way that you've suggested now, that's diametrically opposed to what your briefing has suggested, right?
Correct. The warnings that are on the video were news to me once I saw the video. They're news to my clients. It's different from what the information I had from my clients, that he didn't hear any warnings. So I think that the court below focused on the warnings probably because the cases from Virginia deal with warnings. Warnings are a big issue dealing with police dogs. There are cases dealing with that. But I'm not able to put my finger on it right now. I think it is either the Koff case or the Vatican case in which the court noted that there was a dispute about whether the warnings were in fact heard, and that was a reason to deny a motion for summary judgment. Because obviously a warning can be given if the officer's a mile away, it may not be heard by the suspect fleeing. And of course, the purpose of a warning is to give the suspect time to give himself up. And of course, the case law also establishes that there may be multiple warnings needed. When you look at the Vatican case, they were investigating a burglary into a home. And I think that was the case where there was a dispute about the warnings. I think the officer said that they gave the warnings, eyewitnesses said that they didn't hear any warnings, and the suspect said he didn't hear any warnings. And in that case, the dog was released into the building, unbeknownst to anyone. I think there was someone sleeping behind the door. The dog broke into the door and killed the person. In this case, the fact that the issue of whether or not there was a warning, whether or not the issues were sufficient, is not as critical to a case where the dog is fully released. If an officer has a dog on a leash and says, "Stop, put your hands up, or I'm going to release the dog," and the person doesn't comply, and the officer releases the dog runs to the suspect. That's a different situation. That officer has warned, And after that point, the dog is going to do what the dog is going to do, and what it's trained to do, which is bite. In this case, this officer kept the dog on the leash the whole time. And upon finding Mr. Harrell balled up in the floor of this storage room, didn't say anything to Mr. Harrell. Didn't say, "Sir, we found you now, stand up, put your hands up, you're under arrest." Nothing of that nature. The officer said, "Pack him." And the dog attacked Mr. Harrell from behind, causing extensive damage that I won't go into here, but very severe injuries to a man who posed no threat to anyone at that moment, was not attempting to escape, was unarmed, and there was no indication that he was armed. And the case law is clear that when you're analyzing whether excessive force was used, you look at the moment of the arrest. At the moment of the arrest, Mr. O'Hara was not a threat to anyone, and he wasn't a risk of getting away. He was in a room surrounded by officers and a building surrounded by officers with a dog, all with guns. And he was unarmed. Now, after he was arrested, they found a utility knife in his pocket, but that wasn't known to any of the officers until after he was arrested. It's clearly established at all relevant times that an officer's right to use any force in effecting an arrest is severely limited unless the individual being arrested poses an objective threat. Now, looking at the allegations of the complaint in the light most favorable to Mr. Harold, and even looking at the video, there's no way that a reasonable officer or anybody will think that Mr. Harold was a threat at that time. He's a 130-some pound man with one leg on the ground in a fetal position. Why on earth wouldn't this officer try some less violent means of arresting him? Or even give him one more chance to give himself up before releasing the dog. Instead, this officer silently snuck in, let the dog go around behind, and said, "Pack him," which is attack or seize him in German. In Myers versus Baltimore County, Maryland, a Fourth Circuit case from 2013, this court noted, quote, that courts have repeatedly held that it is not required that a right violated have been recognized by court in a specific context before such right may be held clearly established for the purpose of qualified immunity, and noted that it had stated in, quote, forthright terms that officers using unnecessary, gratuitous, and disproportionate force to seize a secured armed citizen do not act in an objectively reasonable manner and thus are not entitled to qualified immunity. The officer in this case, the level of force that he used was unnecessary, gratuitous, and disproportionate.
So, I mean, in a qualified immunity case, if we were to say qualified immunity doesn't apply here, we need to cite some cases saying this was clearly established. What cases do you think we should cite? What are the best cases for you that show it was clearly established that it would be unconstitutional to use this level of force under these circumstances?
Yes, Your Honor. And I will note, and I think that your law clerks or you would agree that there are not a lot of cases in the Fourth Circuit and in the Supreme Court about police dog cases. But when you look at the case of Coft,
That's what you would.
that's a Fourth Circuit decision from 1990. The police were investigating a robbery. The suspects fled, and some of them were hiding behind a shed or something like that. They released the dog. The dog did severe damage. Now, that case also involved the police officer using a baton at the end. So no case is exactly similar. But in that case, summary judgment was...
Right, it's not, I mean, Cough, they literally beat the guy with the baton.
At the end, yes.
Right, but the court didn't distinguish those and say it's the overall use of force that was excessive. The court doesn't say that the dogs, had they stopped after the dogs, that too would have been excessive.
I agree with you that...
Right, I mean,
I agree.
and it sort of seems inconsistent with later cases to suggest that, you know, in the context that we've got of somebody fleeing, that would be inappropriate. I mean, that just seems like an odd, I mean, I understand why you might want to use it, but that seems like an odd one.
Well, that's one of the ones from the Fourth Circuit. Again, there's not a lot of them. So what
What do
when
you
you-
want us to do?
Well, when a court is considering what's clearly
What do you want
established,
us to do?
I want the court to reverse the decision below, or
And what? For what?
reverse finding that qualified immunity does not apply, or alternatively, I think the court could remand it with instructions to place
You
the
haven't had
burden.
any discovery.
That's correct.
So all you could do would be get discovery. This is a 12B6 dismissal.
Yes, I'm asking
I
the court.
think the most you could seek is to go back and get discovery.
Well, I do think that this issue would be better reserved for summary judgment or at trial. However, it was resolved at virtually the earliest part of the case. So I do think that the case could be reversed and found that qualified immunity doesn't apply, I think that's principally what I'm asking for, Your Honor. Now, when you ask about, when you're talking about the baton and that being a different instrument,
You know what that red light means?
oh, I'm sorry, I do know what it means.
Go ahead and finish your sentence.
Okay. Well, in Myers, the Fourth Circuit case, it said the fact that the force used in the present case emanated from a taser rather than from a more traditional device is not dispositive. So it doesn't matter really what type of weapon or instrument of force was used.
Ms. Safar?
Good morning, Your Honors. May it please the Court. On the night of December 26, 2021, the day after Christmas, Officer Hagan responded to a burglary alarm at the Virginia Cars dealership on Midlothian Turnpike in Chesterfield County, Virginia. This alarm was triggered when Mr. Harold shattered the glass door of the business and forced his way inside. After seeing Chesterfield County police officers respond to the dealership, Mr. Harold did not surrender. Rather, he searched for a hiding place in the building, ultimately moving deeper into the building, ascending the second floor, and hiding in an aisle of a dark storage room. As Chesterfield police entered the building, the first uniformed officer in the door gave a canine warning, loudly announcing, "Chesterfield Police Canine."
Can I just stop you there? How is that a warning? I mean, the closest we've come that I can find to defining what we're talking about when we say warning is in COP, where we say it's supposed to be a forewarning that the dog is going to bite that provides a fair chance to surrender. If all you say is it's a police dog, I mean, why isn't that understood as there's a dog that's going to be looking for you, so you might as well come out? But I didn't hear anything about a bite.
Yes, Your Honor. The warning cases that have been decided by the Fourth Circuit, and there are none by the United States Supreme Court on canines, have not stated specifically what that warning should look like.
Well, like I
but-
said, COP says it should be a warning that the dog is going to bite.
Yes, Your Honor. That initial warning is an announcement that there's a canine in the building. The second warning that was given moments after by Officer Hagan is, "Police canine,
Are you
come on
going
out."
outside the complaint?
I'm sorry, Your Honor. I'm relying on the body-worn camera video that establishes the blatant
So you're
contradiction.
going outside the complaint?
Yes, Your Honor. Under
How do
your
you get outside the complaint in a 12B6 group?
Yes, Your Honor. Under this court's ruling in Doherty, as well as the United States Supreme Court precedent in Scott v. Harris, we are allowed to look at video. In fact, the video controls where there's a blatant contradiction between the video and the facts alleged in the complaint. Judge Harris, you were asking my opposing counsel about that. And there are actually a few references in the complaint to warnings. One of those is on Joint Appendix 10 at paragraph 42, where it is alleged that Officer Hagan gave Mr. Harold no order at all.
No, that's order, not warning. What he's saying there is didn't give any warning at that time that he was going to release the canine if Mr. Harold didn't comply with whatever order the defendant may have wanted to give, but in fact, he gave him no order at all.
Well, Your Honor, there was an order given. It says no order was given at all, but the order was given to come out now in several of the preceding.
But I just don't understand how a reference to no order given at all shows that he said there were no warnings given at all.
Well, if we look at 44 on the same page, JA 10, Yet Officer Hagan did not request or order Mr. Harold to do anything, nor did he give any warning that he was about to deploy the canine. And then again on JA 13 at paragraph 64 and 65, specifically 65 says, Officer Hagan failed to follow these policies and procedures and under the circumstances failed to give an appropriate warning before deploying the canine to attack
So
Mr.
this is
Harold.
right, and this is what the district court relied on, and I had so much trouble with this, because the district court says the footage blatantly contradicts Mr. Harold's complaint to the extent he alleges
Yes, Your
that
Honor.
Officer Hagan failed to give any warning, and then cites these paragraphs, but, you know, that's sort of like a conditional. If he is alleging this, then it's blatantly contradicted, but I don't really read those paragraphs as alleging that no warning was ever given. And I don't even see the district court finding that that's what they say. I just find this very mysterious.
Judge Locke was very reluctant, I believe, to use the BWC,
know.
and she still found, because she read those paragraphs, and she specifically footnoted in her opinion
Yeah, I know.
64
To
and
the extent.
65.
Right, I just find what, you're reading it as though the district court said it blatantly contradicts the complaint because he alleges that he failed to give any warning, but that's not even what the district court says. I am genuinely perplexed as to why the district court, what's
Just so-
going on here.
Just so I understand your argument, sorry, I'm catching up slowly. Your argument seems to turn a large on paragraph 44, where it says Hagan did not request or order Mr. Harold to do anything, nor did he, that being Hagan, give any warning that he was about to deploy the canine.
Yes, Your Honor.
And your point is when somebody walks in and says, police canine, that in your view, that is a warning that the canine is being deployed.
I think more specifically, Your Honor, that the second warning that was given was police canine, come on out now or I'll release the dog and the dog bites. You will be bit, you understand me?
Okay,
That's
counsel, can I just stop you? Because the district court transcribed that differently as police canine, come on out now, and I'll release the dog and the dog bites. And so my clerk and I have spent a lot of time listening to the video. It's very unclear at best which one it is. So do you think the district court just got this wrong, or did the officer get it wrong in the heat of the moment? What happened here?
Your Honor, I had noted it as, or I'll release the dog and the dog bites.
Right, but on JA 43, when the district court says what the warning is, I know that's what you have in your brief, but it contradicts the district court's transcription, which is police canine, come on out now, and I'll release the dog and the dog bites. You will be bit. So I just want to know what you think I'm supposed to do with that.
Your Honor, I had it as, or I'll release the dog and the dog bites.
I
If
know.
it is a transcription error, I'm not certain. I listened to the audio myself.
You thought the audio was clear on that, because I didn't.
Yeah, I think it's clear that they're saying, come on out now or you will be bit. And that's the subsequent warnings as well. The third warning is police canine, come on out now.
Nope. The come on out now, I could hear clearly. I couldn't, the and versus or, doesn't matter.
Does it make a difference to your argument whether it's and or? I know sometimes we like to talk about the disjunctive and conjunctive here, but does that make a difference for your argument?
Your Honor, it does not make a difference. Under Harris and Doherty, this court is entitled to consider and ought to consider those blatant contradictions. In Putman versus Harris, decided in 2023 by this very court, it recognized that the body-worn camera should be considered and that there had been no opposition by opposing counsel to using it. So to Judge Richardson, to your point, with my opposing counsel, there was no dispute in the briefing that the body-worn camera should be considered on those points with regards to the warnings having been given. So considering those 6 warnings, this is a violent felony under Virginia Code and federal law, a nighttime breaking and entering into the car dealership. We have officers that respond. The canine entrance is given with the announcement downstairs. There are 6 total announcements or warnings or commands given. 3 of those take place on the 2nd floor, which is where Mr. Harold is hiding. It is obvious, it is conceded in the complaint that Mr. Harold sees police, and after he sees police, he flees to the 2nd floor to hide. I believe opposing counsel said in his briefing that his client was not able to find an appropriate hiding place on the first floor, so he actively fled to the second floor. So now we have a suspect that has actively fled from law enforcement and has concealed himself in a dark storage room on the second floor of the building in an aisle that is cluttered. And there are 3 announcements and warnings given on that second floor, one of which is in the very room in which the suspect was located. When Officer Hagan locates the suspect, Mr. Harold, he is crouched down in the aisle behind computer equipment and cardboard boxes. Judge Locke, when she reached her opinion in the district court, she found that the first Graham factor, whether or not the severity of the crime favored Officer Hagan, she said it was a close call and went in favor of the suspect Harold as to the immediacy of the threat. Judge Locke erred in reaching that conclusion, in part because she didn't take
You're saying Judge Locke erred when she said it's plausible that Officer Hagan's use of force was objectively unreasonable for failing to issue a final warning before deploying Kona.
Yes, Your Honor.
Did you cross appeal?
I did not, Your Honor. It is not required, nor is it actually permitted, because there was not an order entered that was a ruling contrary to my client. This court has recognized in numerous cases, as has the U.S. Supreme Court, that when you are talking about a cross appeal, there is not a need to cross appeal.
So in Judge Locke's opinion, you lost on the constitutional claim?
Yes, Your Honor, but we, of course, request this court to affirm qualified immunity, but we encourage the court to reach the first prong and, if necessary or appropriate, the second prong. For purposes of review...
So you want us to vacate and remand?
No, Your Honor.
Well, there's been no discovery.
Your Honor...
All we've got, there's been no discovery here. This is a 12B6 ruling. 12B6.
Yes, Your Honor. This is qualified...
The complaint fails to state a claim upon which relief can be granted. And she says it's plausible that his use of force was objectively unreasonable.
Your Honor, that's because when
she... ruled against you and you didn't cross appeal.
Your Honor, the Fourth Circuit has stated in Reynolds versus American National Red Cross that we're seeking affirmance of the district court's judgment on an alternate ground or a different reasoning. Cross appeal is not necessary. So this court's precedent, both in that case as well as its qualified immunity case law, including Maney and Melgar and the other cases, because qualified immunity requires the court to consider one of 2 or both prongs, there is not a need to note a cross appeal in order to make this argument. It is automatically before the court when qualified immunity is appealed that the court under Saucier versus Katz and Pearson versus Callahan considers both prongs.
So what is it you want us to do? You want to win on the other prong?
Your Honor, I'd like to win on both prongs, please. I'd like for my client to win on both prongs.
Well, but you've already, the ruling was your way. You prevailed on the second prong and you didn't bother to appeal this first prong.
Well, Your Honor, that's because
she ruled against you.
There isn't an order to appeal from because we won in the lower court. We would, of course, like for the court to affirm on the clearly established prong because in the, if the court's lower court cases that it looked at, there are only 7 cases out of the Fourth Circuit that deal with canine seizures or canine bites, and only 4 of those are published.
What bothers me is you want us to do all that on a 12B6 ruling.
Your Honor,
There's been no discovery at all.
The expectation...
We don't have a record.
The expectation of the U.S. Supreme Court is that qualified immunity will be considered and given at the earliest stage appropriate.
I've been around the horn a couple times. I've heard of qualified immunity.
Yes, Your Honor. The reason that we've asked for the court to consider both prongs is because there are only 4 published cases out of the Fourth Circuit that deal with canine seizures. The most recent...
So you want an advisory opinion that would go your way?
No, Your Honor. I think that the police officers...
Without any discovery?
I think police officers in Virginia and in the Fourth Circuit are entitled to know whether or not it's objectively reasonable to release a canine to seize a suspect whose hands are hidden.
Judge Locke said it's objectively unreasonable, right here.
And Judge Locke...
In this case, objectively unreasonable.
And Judge Locke relied on the allegation...
And you're saying Judge Locke is wrong, but you don't appeal her ruling.
Because, Your Honor, I'm challenging the reasoning behind her ruling, which is not the same under the Fourth Circuit law. Judge Locke, in reaching that conclusion, relied on the allegation in the complaint that the suspect was laying motionless on the floor when he was found. If you look at 3 minutes and 37 seconds into the body-worn camera video, It shows that he's not laying motionless on the floor, and it shows that his hands are concealed.
But there's no possible, I mean, there are lots of things you ought to be saying, I get that, but like, there's no possible reason that you're suggesting that we're gonna reconsider Judge Locke's factual findings on an interlocutory appeal under qualified immunity based on our view of the video. We have to take the district court's findings as they come. Because it's an interlocutory appeal. We only have jurisdiction over legal questions, not factual questions.
Well, Your Honor, it's a final order in this particular case. It's not an interlocutory appeal because we prevailed below, and it's not summary judgment, so her decisions of fact aren't the same. But I can see that there is some hesitation about reaching the first prong. I think the first prong is compelling, though, because part of what you see that shows the immediacy of the threat.
Why don't you talk about the second prong a little bit?
Yes, Your Honor. On the second prong, the law has to be clearly established. And we know from all of the recent rulings of the U.S. Supreme Court, including Casella versus Hughes and
Well, it's
Escondida.
clearly established, you can't use excessive force.
For clearly
If you
established.
agree with that part, you want to be more specific in your position.
Yes, Your Honor. And
But
clearly,
it's clearly established, you can't use excessive force.
it is clearly established that you can't use excessive force, but the case law has to establish a bright line. Officers are not held liable for reasonable or for mistakes. They have to have been plainly incompetent in their actions, and there has to be case law that squarely governs the facts of the case. Here, the case law that we have that is published in precedent are Koff, Vatican, and the Melger case.
Why can we only look at dog cases? I mean, we have said, and I think your colleague quoted one of the most recent times when they've said this, like it doesn't, like you can use taser cases and baton cases, like the means by which the force is
Sure, Your Honor.
applied, we can kind of borrow from other cases,
Even
right?
in Putman versus Harris, which was taser and canine, and the Myers case cited by my opposing counsel, which was a taser case, the courts have said that it is appropriate to use force to seize an individual when there is a high threat of violence related to the crime or the conditions, and the suspect is evading or attempting to flee. In
But
this
we also
case,
say all the time, it's like the moment at which force is employed is what matters. And what's alleged here is that at the moment force is employed, he's not fleeing, he's not attempting to evade, and he's not a risk.
well, Your Honor, first of all, Barnes versus Felix, issued by the United States Supreme Court this year, clarified that the actual viewpoint needs to be the totality of the circumstances without putting chronological blinders on the court. So for that purpose, we start all the way back with the entrance into the building. It educates the officer's decisions. An officer is not going to, in this particular case, the officers gave warnings, they gave commands, they announced their presence. Under Koff and Vatican, that is what this court said was expected before you release a dog, and this officer did exactly
Is your
that.
argument that that is sufficient to make the use of a dog reasonable? If a warning's given, that's all we ask?
Under the facts of this case, Your Honor, absolutely.
Okay, so only on the facts of this case, but which of those facts, like what facts? We don't have a record here. We don't know what the officer saw when he walked into that room. We don't know what the officer perceived. I understand it's an objective inquiry, but we care what the officer thought. Like, we don't have any of that
What
here.
the officer thought isn't relevant. It is objective reasonableness. And when
We
there's
have said several times, let me just stop you, that although it is an objective question, we care what the officer thought because that sheds light on what a reasonable officer would have thought. It's not one and the same, but it's certainly relevant, which is why we generally don't decide these cases until we can get the officer's account of what happened.
The officer's body-worn camera video shows that he encountered a suspect that had broken in to a commercial establishment at nighttime, had fled to hide. Under Fourth Circuit case law, hiding from an officer is an attempt to evade
You
arrest.
want to put your case in through the video and not have anything else in the case, not have any depositions, not have any record made.
Because,
And all you, this is 12B6.
yes, Your Honor, but,
It should be decided on the complaint.
Your Honor, this court has said that when
I know what the court has said, a few things, but I'm telling you what I'm saying. We should be deciding these things on the complaint. And if we're going to get outside the complaint, we ought to have discovery. And let's
officers,
depose these officers.
officers
And
are
let's find out
entitled,
what's going on. And you come in here after the judge has ruled against you, and said that Officer Hagan's use of force was objectively unreasonable for failing to issue a final warning. And you did cross appeal, but you want us to vacate that ruling.
Your Honor, I'm asking
That's
you to...
exactly what you want. You want us to vacate her ruling against you
I'm asking the court...
without a cross appeal.
I'm asking the court to affirm the ruling on either prong.
And you want us to vacate the first one. You told me that earlier. You want us to vacate the first prong and win on the second prong. You said you wanted both prongs ruled on.
Your Honor, this court is supposed to look at both prongs when it's appealed. That is the way that it works. If you look at the court's...
Well, we can look at either one under
Yes,
the
sir.
Supreme Court precedent.
You can take either one first, Your
We know
Honor.
how to do this kind of thing. We get a lot of these appeals.
You can take either
But
one first.
You want us to take up your claim about the first prong without a cross appeal.
Your Honor...
And you know how to file a cross appeal.
Your Honor, I would like for the court to affirm on the second prong that the law was not clearly established such that it prohibited Officer Hagan from using a
The law is
canine.
clearly established you can't use excessive force. And the question is whether sicking a dog on a guy with one leg curled up in a ball and doing excessive damage to him for up to a minute, biting his vitals. I've read some of this record.
Your Honor,
That happened.
that is the complaint. That is not the BWC.
Well, we take that as true.
And
That's in the complaint.
Then Doherty is given no meaning.
This is 12B6.
But Doherty said that the court is to consider blatant contradictions. So we, as practitioners and as officers, are following the laws that have been written. That's the point of qualified immunity. The officers are acting within the scope of what they have been told is permissible, and there's no clearly established law.
And what is it that you think this video blatantly contradicts, putting to one side the earlier announcements/warnings? Like, what else is blatantly contradicted? 'Cause, I mean, I
The
looked at the
suspect was
video,
not
you can
laying
barely
motionless
see anything.
on the floor. He was hiding behind a box and computer equipment with his hands concealed.
I could not figure out whether, the hands concealed thing, I'm not really getting from the video.
May I answer the question, please, Your Honor? At 3 minutes and 37 seconds on the body-worn camera footage, when Officer Hagan gives the directive to the dog to seize the suspect is bent over behind boxes and computer equipment, and the lower part of the suspect's arms and the suspect's hands are not visible.
Well, it's not visible to the camera, but we have, perhaps, I find the whole thing kind of hard to follow, but unless the officer is exactly where the camera is, we don't know what the officer could see.
Your Honor,
And that's what is so weird about this case. There's not even the officer's account of what he could see.
Your Honor, it's clear from the camera, given the distance that the suspect is hiding behind boxes and equipment and how low the equipment is, that his hands are concealed. And a suspect, in closing, an officer who encounters a suspect that is concealing their hands and hiding themselves is an appropriate time to use force. And if it's not, it is not plainly incompetent for an officer to utilize a canine in those circumstances based on the law that is established within the Fourth Circuit and the U.S. Supreme Court. And for those reasons, I would ask that you affirm Judge Locke's ruling awarding qualified immunity to Officer Hagan in this case.
Thank you very much. Mr. Allen?
Your Honor, it's on the issue of what the officer thought. I do think that it's important to know, and as alleged in the complaint, one of the sergeants for the police department testified at Mr. Harrell's preliminary hearing that they didn't see him with a gun and they didn't have any reason to think he had a gun. And so I would have liked to have had that considered by the court below in determining whether force was appropriate, because it is. You look at the moment, of course, of the arrest. And there's a lot of focus on what happened beforehand.
But, I mean, the district court didn't rely on there having been a gun seen, or, I mean, like, there was not a suggestion that he was carrying a gun.
Never,
right?
or any weapon.
It just seems like that's an odd point to try to make, right? Is that,
Well,
there might be lots of things that you want to do, but there's uncertainty, right? But nobody says that they saw him with a gun. Nobody saw a gun. So, like, why is that the point? I guess
Well,
I'm just a little confused.
Well, it's relevant to a certain degree, because if a person has a gun, if there's an armed robbery and police are investigating an armed robbery, clearly they can assume that the person may be armed and dangerous. But if there's an officer just can't assume that everyone is dangerous. I mean, for heaven's sakes, it's in this country, everyone can carry a gun if they want to. So that doesn't necessarily, bottom line is, in this case, there's no evidence that Mr. Harrell was armed or that any of the officers
There's no
thought he
evidence
was
in
armed.
this case. He could have assumed that he had a gun. We don't know.
Well, an officer can't just make assumptions like that. It has to be based on the facts.
Well, the complaint alleges that, I'm going to forget the exact language, but something like the officer knew or should have known he wasn't armed, and we're supposed to, draw inferences from the complaint in favor of the plaintiff. So I'm wondering if we can infer that he's alleging.
It's
that the
alleged several
officer-
times that he was unarmed.
Right, but not only that he was unarmed, but that the officer knew he was unarmed or should have
Well,
known he
that-
was unarmed. And I'm wondering if we can infer from that he is alleging that you could tell I wasn't holding a weapon.
It was Sergeant Murphy who testified at a preliminary hearing that he wasn't armed and they didn't think he was armed.
Okay.
I wanted to talk briefly about the warning.
Is the preliminary hearing record in this record too?
It's not in the record.
Well,
I
then
have
how
a
do
copy
you
of
all
it.
You're just like the other side. I thought it was a 12B6 case. I came in here, and they were talking about everything but what's in the complaint.
Yes, Your Honor, that's true. I have a copy of it. I have my client's own testimony and all of that. I would like to present in opposition to a summary judgment. Now,
It's not a summary judgment.
I
It's a
know.
12B6 dismissal.
Right.
They threw out your complaint on the face of the complaint.
even earlier, it's outrageous. Now, on
You're
the,
trying to get to discovery so you can argue about summary judgment.
yes, thank you.
Now you've got to get discovery.
I'm with
And
you,
you'll
Your
get
Honor.
depositions, and the officers, and depositions of your client.
That's right.
And then the court can consider summary judgment if it gets that point.
Correct.
But here, we're here on a Rule 12B6 dismissal.
Correct, and I do think that all of those things should be explored before a case is dismissed. And I will say that in this case, this officer is now charged with drug distribution and is no longer an officer. So there'll be a lot of
That's
things.
not in the record either.
Is that in the
That's not in the
complaint?
record, but it will. I'd
That's
like
certainly
to put
not
it in the record.
It doesn't have anything to do with it.
Right.
Where was the officer for Thanksgiving? I'm just sort of curious, right? It's like, I mean, we're like so far afield from anything that's like even arguably pertinent.
Right. Well, I want to speak to the warning, and what exactly was said. Standing here today, I don't know. I'm going to obviously listen again. But there is, in my mind, a very big difference between police canine come on out and I'll release the dog. Who would come out? If the officer said come out or I'll release the dog and the dog will bite, that's a warning where the person will have an opportunity to give themselves up. If the officer says come on out, I've got a dog and I'll release the dog and the dog
We
will
don't
bite.
typically interpret these things like statutes, right?
Right.
Like, a reasonable person hearing that would not understand that I will only release the dog if you come out.
Well, I think that it's a very big difference. I think my colleague said that she didn't see a difference between the and or in that. I certainly do. So again, you look at the moment that the arrest was made, and I would draw the court's attention to the Crime v. Price case. That's a case where officers were investigating a traffic situation, and the vehicle was coming towards the officer. I'm sorry, I see that I've done it again.
Finish your sentence.
And the court found that the officer was justified in shooting at the vehicle while it was approaching them, but not justified in doing another shot once the vehicle had passed.
Thank you very much, Mr. Allen.
Thank you.
We appreciate counsel's arguments. We'll adjourn court until tomorrow morning, and then we'll come down and greet counsel. And thank you very much for helping us out.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.